Welcome back to the Michigan Business Beat, brought to you on the Michigan Business Network. I'm Chris Holman, of course, and we are broadcasting remote and mostly in Southfield right now. As a matter of fact, Anthony Dalimonte, he's an attorney with Foster, Swift, Collins, and Smith in Southfield, Lansing, and really all places Michigan. When you think about it, this group is on a real growth pattern and has been for a number of years. Anthony, welcome to the show. It's good to have you here, and you have some really valuable information for us, so I'm glad you're available to share it.
Yeah, thanks for having me, Chris.
So on January 5th, which wasn't real far into the 23 calendar, the U.S. Federal Trade Commission, the FTC, issued a proposed new regulation that's going to broadly prohibit employers from using or enforcing non-compete agreements. And employees, former employees, contractors, other workers, all these people are covered. So first of all, a little explanation for what a non-compete agreement is.
Sure. So, non-compete agreements or clauses essentially prevent an employee from seeking or accepting work with a different employer, usually one that's in competition with your former employer, following the end of your employment. So basically some contract clause that prevents you from going and working somewhere else.
It's kind of interesting because I just interviewed an employer who said they had one of their valued people move for an extra $20,000, but the company she moved to anticipated she would also move clients. And when that didn't happen, it didn't work out. And she's like on her third employer since. So these things have ramifications. So what would this proposed rule by the FTC do to current non-compete agreements that are in place?
So the proposed rule would do three things. First, it would forbid employers from entering into non-compete agreements or clauses with their workers, and that includes independent contractors. Second, it would rescind all existing non-compete agreements with their current workers. And third, it requires employers to provide individualized notice to employees that are subject to non-compete agreements that those agreements are no longer in effect and they may not be enforced. And the FTC's basis for this rule is essentially that non-compete agreements are an unfair method of competition. And so, like you said, this came down about a week ago, and it's got everyone up in a stir, and it's important stuff.
This is a typical regulation written without small business being part of the process, because the unknown consequences of this are going to be unfathomably deep. Are there any exemptions for businesses or employers?
Not really. The proposed rule is a blanket ban on non-competes. The one exception being non-compete agreements related to the sale of a business where a person or an entity is at least a 25% owner in the business. Other than that, there's no exceptions.
Wow. So does this rule affect any other employment restrictions such as non-disclosure?
So the proposed rule includes a very broad definition of what constitutes a non-compete clause. And I'm going to briefly go through that. It's a contract term between an employer and a worker that prevents the worker from seeking or accepting employment with a person or operating a business after the conclusion of the worker's employment. So that basically means, any contract term that prevents someone from going and working somewhere else is considered a non-compete clause and would be banned. Not only that, the FTC has told us that de facto non-compete clauses that have the same effect of prohibiting employment are also prohibited. And they give us some examples of what these de facto agreements are. And, so they're broad non-disclosure agreements, confidentiality clauses, and clauses that would require an employee who resigns within a specific period of time to pay the employer back for training costs. So these types of clauses would also be prohibited. The FTC doesn't explicitly address whether non-solicit agreements would be deemed a non-compete clause, but because of the broad, definition of non-compete clause, they could be included.
So let's ask, what are the next steps that the FTC is going to take?
Well, the next steps are the proposed rule will go into a 60-day comment period, where the public and interested parties can submit comments through a link on the FTC's website. Then if the rule passes, the FTC will publish a final rule that will be effective 180 days after publication. So the earliest that this could become effective is September of 2023, but our thinking is that given the broad application and effect, this rule is likely to be challenged in court, which would probably delay or prevent enforcement, at least for a period of time. But it's a big deal. We're early in the process and still trying to sift through it all, but it'll be interesting to see how it shakes out.
Yeah, but this will help you make the small business call that you want to make, because now is the time for business to get their comments in with the FTC.
Absolutely.
Yeah. Anthony Dalimonte, attorney with Foster Swift, Collins and Smith, with offices throughout Michigan. Thanks so much for joining us. We appreciate this, and we're going to call a whole lot of attention to this, Anthony. Thank you.
Yeah, absolutely. Thanks.
All right. You've been watching the Michigan Business Beat on the Michigan Business Network. I'm Chris Holman. Stick around. Believe it or not, there's even more ahead.